Welcome back to part two with David from Planning Alliance. Like, subscribe, and
Or
enjoy the call.
viewing it the other way, if something's illiquid, you'll take a one-third discount in round numbers, right? So the question is who should they have the right to sell? Well, obviously, within the ownership group, you'd like to have a right to sell. You say, what about outsiders? Well, let me give you an example of someone who made an agreement with someone and took the right to sell to an outsider off. He had a couple of key executives in the business. One was a nephew. And he entered into an agreement with his nephew that he would never sell the business to an outsider. That's a mistake. You've automatically, by entering into that agreement, knocked 50% off the value or knocked a third of the value off your ownership just by signing that. It's a mistake. Other things that we've seen are restricted are intra-family transfers. People who want to do their own planning and they're blocked because their agreement says they can't transfer their interests. Now, I understand why we would have that in there, but maybe they can transfer economic aspects of their interests. Maybe you can't transfer your right to sit on the board, but that doesn't mean you can't transfer other aspects of your economic interest in your business in that example, right? Things that we found transfers of small interests in ownership. Usually somebody like the CPA says, oh, you have to give shares to your kids or things like this. Um, And we are against transfers of small interests. If anybody wants to know why, we can go into more depth on it. But you do end up often with the tail wagging the dog. And you also sometimes end up with unforeseen consequences. So an example, these are all actual. If I give you examples, they're actual. They're not, I read it in a book. We had a group of people worked together, decided to buy a building somewhere in Manhattan for privacy purposes. The real estate project was successful. I'm going to say three initial owners. There was really four, but two of them were married. So the three owners, this project was successful, and one of them got divorced. In the divorce, the judge awarded half the interest of the divorced person to their spouse. Their spouse got remarried, and then the spouse died, and they ended up with the widower of the spouse who they knew nothing about as their partner in this closely held project. I'm just using that as an example. All right, there can be unintended consequences. Um, Something that we've seen is where unanimity is required on all decisions. It's not uncommon to see that in an agreement, but that is oftentimes a mistake because that's a formula for paralysis. Right? It's a formula for paralysis unless you've got, and I'm a little out of order here, unless you've got deadlocks. What happens if it's deadlocks? It's addressed. And this is one of the most common areas that we are concerned with, that we see in agreements, is that the deadlock mechanism is not workable. In other words, you'll see, okay, we have a deadlock. Corey, you and I are partners. We have a deadlock. All right, you show up and you tell me the price, and I'll tell you whether I'm buying or selling. And then I have 30 days to close. I call this the Mexican standoff. We've all got guns pointing at each other. All right, it's completely unworkable because if you come to me and say, here's the price, and I say, you know what, I want to buy you, 30 days isn't enough time to get financing together as an example. It's completely impractical. Whereas you could have been planning for that moment. You've got the banks lined up, this, that, you got everything set up. I'm just using that as one example. So with that, if the deadlocks are not addressed or they're addressed in an unworkable fashion, is a common mistake. The ability of a minority owner to block borrowing, or actual case, the ability of an owner to avoid participation in a loan guarantee. Example, we had a hotel where there were five owners in the hotel, but only one of them signed the personal guarantee, right? This is common, or one of them guarantees the lease, or things like this, right? See it all the time, right? If there's a provision for, well, first of all, is there a provision for a for-cause dismissal in your business agreement? And is it workable? Can it actually happen? Something to think about because what we found in agreements is there is no medieval torture that is too vicious that one partner won't do to another if they cheat them in business. Like when we find with executives, they're far more concerned about getting protected from being unfairly terminated for cause, but the owners are willing to kill each other. If you cheat me, you die. All right. But is it actually practical? Can it be administered? Others we've seen is there's a buyout provision, but the buyout provision is too onerous. In other words, now this wasn't the real estate, but I just want to use this as an example. We had an oral surgery practice where we were brought in. It's a very successful oral surgery practice. And the older partner had an agreement to get bought out from the younger partner. And looking at the agreement, we said there's no way he can afford to pay that. Well, no, he signed it. So we speak to the younger partner. Why'd you sign this? Well, my attorney told me if something happens to him to just file for bankruptcy and move to Israel. This was the legal advice he was given. There's no way that he could possibly meet the buyout provisions that have been in what he signed in order to be a partner in this practice. Buyouts are unfunded or underfunded, ignoring of risk. And here's one that I find interesting because we are in the insurance business, is insuring the wrong parties. So we do quite a bit of intra-family transfers of businesses to the next generation or subsequent generations. And oftentimes there's a focus on ensuring the founders, the patriarchs, the matriarchs, and that's not always the right party to insure because most intra-family transfers we do as sales. The parents are getting bought out by the children. I'm going to say that's 90% north of 90%. They're not just given to the next generation. There's exceptions to everything. But if the children are buying you out, they're responsible for paying. Or if your management team is buying you out, they're responsible for paying. So who are we insuring here? The ones who are getting out or the ones have to pay to get them out? I'm just using that as common mistakes we see. And then very briefly, I wanted to talk about valuing businesses. Now, this is just one aspect of it, but I'm willing to go into valuation in as much detail as you want here. But I just wanted to bring up this one aspect because we haven't seen it brought up by other parties, including those that do a lot of advice, big law firms, CPAs, etc. And that is if I'm transferring a business, particularly to my children, if I'm transferring a business to my children or to my executives, I want to avoid I want to have control over that value. Usually we want a lower value, right? Usually because we're state taxes, whether at the state level, et cetera, but we want a lower value for various reasons in that intra-family transfer. And what we say is, well, when you're doing your valuation, you're missing something because, if you go into a business, or let me put you another way, everyone here, a lot of you are CEOs. Well, what's next? What's your job after the CEO? Where do you go from here? This is a little antiquated. We used to say you end up in the mailroom. I'm not saying businesses have mailrooms anymore, but we would go into the closely held business. You'd have somebody in there a little older than me. Their glasses might be a little thicker. They might be a little more stooped over. They come in a little later than everybody else. They look around. Generally, things don't meet their approval. They go in, they collect the mail. Maybe they have lunch with a longtime colleague and they leave. That person is the CEO, right? That's their next job. And but they're getting paid $400,000 or $500,000 a year for that job, right? It's their company. So our argument is, well, every closely held business has some obligation to continue paying its owners, including if you sell your business, you're most likely going to take back some kind of consulting agreement, employment contract as part of your agreement. That should be valued. It should be formalized. Why should it be formalized? Well, one, so we can value it, but number two, what's the problem with being an owner? The problem with being an owner is all your capital's at risk. It's not the only problem. But if I have a deferred compensation agreement, I'm no longer an owner to the extent of that deferred compensation agreement. I'm a general creditor. I have more rights than I had as an owner. So we should be setting up deferred compensation agreements for these founders of these companies, recognizing that when they step out, the main thing they're looking for is to continue their income and lifestyle. Formalize it, put it on a balance sheet. You can make it subordinated to the bank debt. And then, if I'm going to sell this business to a trust for my benefit of my children, not to my children, and take back a note, I'm now selling at a lower value. Right? I just wanted to mention that. And I wanted to mention just one other thing, and then our presentation will be done. Is the most common mistake I see in the fact finding. I skip this. The most common overlooked fact that we find is overlooking the implication of debt on the business. Because debt comes with covenants to it of various kinds and default provisions and personal guarantees. And very often, the death of a guarantor triggers a default under the loan. Most of the time, right? Most of the time. We had just one example, and then we'll take questions and answers if anyone's interested. One example, we had a $50 million contractor. I know somebody was asking about construction. This is a number of years ago, but 50 million is a good sized contractor. Maybe with inflation today, it might be 75 or 80 million. They did public work. And I was asked to come in by their financial advisors to meet with their law firm. They were a little intimidated. I go to meet with them. There's three attorneys in the room. They're explaining all the planning that they're doing. Background fact, this guy had a $100 million performance bond. It's a $100 million bond because he's bidding on large public jobs. So I asked the attorneys, I said, did he personally guarantee that bond? They said, we don't think so. I said, you don't think so? We don't think so. Well, why don't we get a copy of it faxed to us? So we called the controller. They faxed us the bond. Who guaranteed the bond? The husband. Who waived his homestead exemption when he guaranteed that bond? The husband. Who else signed the bond? The wife. Who else signed? Who else waived their homestead exemption? The wife. He had 7 commercial properties that he was building. Coming back to people in the construction business, they're always building investment properties. He had 7 of these. Everything that they had was at risk on this bond. And their planning ignored that fact. They had no creditor strategy at all. I could go on with the facts in this case, etc., but that's just a brief introduction of some thoughts on continuity planning and agreements. Would anybody have any questions?
Be sure to come back for part 3. Like, subscribe, and drop us a comment. Thanks for watching.